All right, you're live. Okay, welcome everyone to a joint meeting of the Rule and Accountability Committees of the Cleveland Community Police Commission. It is 6:06 p.m. on Wednesday, May 1st. So we're going to start with our call to order roll call. So, Shonda Benito.
Present.
You're a member of both the Rules and Accountability. Charles Donaldson.
Present.
Welcome back.
Pete Van Leer, Chair Pro Tem of the Rules Committee. Terry Wong.
Present.
Jim Tura.
Present.
Kate Kennedy.
Present.
Along with Ferguson is on leave. All right, so the agenda is to start talking about the evidentiary manual, figure out next steps. We're not going to take any votes or make any decisions necessarily, but we just.
Could we? There's another person that you're involved in introduction.
Oh, yeah, sure.
I think he's going to, right?
Yeah,
I don't know.
that's fine. No, we can do that. I was going to talk about the agenda, but would you like to introduce yourself, sir?
I am Brandon Mordew.
Oh, great. Hey, thanks for being here.
Okay, and we also have co-chair Johnny Adams with us today. So anyway, the agenda is basically to talk about, some of the issues, main areas of concern and how we want to address the CPC's evidentiary manual draft, and then next steps. And if we have time, the Rules Committee will dig in on Rule 1.4.5, which we got more than halfway through a while ago, but that work has been sidelined. So we'll see how it goes. So any questions about the agenda? Anything that we need to do with it different? Okay. Yep.
I would, the reason why Mr. Mordew was brought in and volunteered his time is that I hope we get into an in-depth discussion, because every line of that manual will be torn apart, in arbitration. So I think since we have him here, to only utilize him for broad things, we could have done that by just reading his email. So I would hope that we would have a more sincere discussion of this draft.
Yeah, my goal was not to have an insincere discussion, so point taken. Anything else? All right, is there any public comment? Anybody from the public want to comment?
Actually, I'm looking forward to the discussion first.
Excellent. All right, so it doesn't look like we have any public comment, so let's just jump into the discussion on the evidentiary manual. So I feel like, one thing that might be helpful is to think about some broad categories, like where, all right, so for, looking through it, there's some comments around sticking closer to charter language, clearly identifying process procedures. So maybe we could start by highlighting, say, here's some major themes or areas where we need to do some work, and then we can dig into a deeper discussion. Does that make sense? Commissioner Wong.
As I pointed out, I've made already 57 comments on this. Mr. Mordew seems to have made about the same. That would be fine, presuming that this draft did not require that level of revision. I don't know exactly what Mr. Mordew had envisioned, but he wanted some kind of foundational questions answered before we can even structure. Is that what is that?
I'm just a guest here.
Yeah, before we can structure.
My point
But
is
if I can finish my statement is that this should not be used as an attempt to legitimize this draft at all, because I will go on record that this is a very, very flawed draft, and to just do kind of sentence by sentence topical things. I think we need to have like a foundational discussion of what is actually really wrong. There are things that were not properly configured in this at all.
So I think we're saying the same thing.
To the chair,
Yeah.
we're getting off on a foot where there's accusations being made that, so the public needs to know, one, this draft was created with the staff of the CPC, by the executive director, and primarily through our attorney, Martin Belot. So anyone who says, it's open to opinion, right? There's a lot of feedback and opinion that can come from many different sources. We don't have emotional attachment to this draft, so feel free to change it. But what I do want to say is any accusation that this draft is unlawful or has serious problems related to a arbitration process is coming from not a legal opinion that is sanctioned by the CPC. So while we can get feedback and feedback will come from multiple sources, there are no official legal opinions out there that the CPC solicited that says this draft is in violation of any law, the charter, or anything else. So I just want to be clear on that. It's great to have feedback from multiple sources. It's great to have guests if this was agreed upon to bring a guest in to provide feedback and insight. But to say that there is anything that is illegal about this or conflicts do arise in law, that's why we have lawyers. If there weren't legal conflicts and legal opinions, we wouldn't need lawyers. So we can have multiple lawyers look at this, and you will probably get multiple opinions from attorneys on what is wrong and what is the conflict. But it was created with the law department's input, feedback, and the charter, consciously aware of the charter. So.
Okay, Commissioner Donaldson, you had hand up.
Yes, through the chair. I just want to make sure that I was looking at the correct draft. So I have one that's titled final draft and then one that's titled 4324. So I'm assuming the final
link
one.
that I sent, it's a live Google Doc. If you
Okay.
It says final draft. I mean, is there,
Because there were the other drafts that we sent out. So we might as well just look at the one that has all the comments.
right, the one with the comments, so it's the one that says CPC evidentiary manual final draft.
Okay, that's the
That is
one.
a Google Doc.
Yep, thank you.
That's one we can- Commissioner.
I thought that your idea was a good one, and I would just encourage us, like, let's have a discussion about the concerns and about the topics, and we've had a lot of back and forth, you've made your point.
I've not made my points, but I was
Okay,
Okay, let's
actually.
not get into a discussion. You don't
can I
want to. Well,
I'm also actually not even clear who is
I-
supposed to be the
I
chair.
am chairing this meeting.
But it's a joint
The
meeting.
accountability committee was invited
Okay,
here, so
well,
I'm
then
just.
we will go by it.
Okay,
I
is
would,
it okay for me to continue my comment?
I raised my hand before her, but you can choose to.
Let's just talk, all right, go ahead.
I would just encourage us to talk about the issues, and you've made your point many times that you don't think that this draft is sufficient. And I think that hopefully through having more of a concrete conversation about substantive clear issues, we can either get to a point where we think that we can revise this draft, or as you have been saying, that you think it needs a full rewrite. But I think that the point of why we have everyone together here is to try to figure that out. And so I would like for us to move to the issues and to stop the back and forth about how bad the draft is or what needs to be done. That is what we're trying to gather here to achieve and discuss.
Commissioner Wong, I'd like us to stay focused on
I
this
do,
work and not, again, as
I
Commissioner
understand.
Benito said.
I understand.
No, as Commissioner Benito said, let's not answer each other back and forth.
However, I
Let's
do want to
focus on the
go
draft.
on record about what I said that was
So no, we're
misconstrued.
not gonna go into that. We're gonna go and focus on the work at
You
hand.
cannot,
We need to
you
focus
have
on the
an
work at hand.
inaccurate record here. What
It
is out
doesn't
of
matter
order
what,
about?
let us
I
talk
just
about
let me
that,
make-
because we're gonna
Then
waste
it'll
time.
be faster if we don't argue about this and just let
All right,
everybody
one
speak freely.
more chance, just real quick, all right? We're not gonna get back and forth after this.
My concerns
Stop.
about the draft were based on the content of the draft. And also I want to be on record that I did a public records request for the emails contained in the draft. And I'm concerned that the people that had access to this draft were not the commissioners, but were members of the city law department, lawyers for CPRB, and even city prosecutor of Willa Jordan. This is the reason why I asked Mr. Mordew to look at it, and why you also asked other lawyers to look at it, because it's not a balanced procedure or way to create a process to have only city law department attorneys look at this and not counterbalance that with lawyers outside of the ecosystem. And I do want to go on record also saying that I might be in the minority right now, but I do believe, and it's nothing personal against Mr. Galat, that I do believe that he is in a wide conflict of interest. So this draft has not really gotten, in my opinion, the diligent and rigorous kind of legal eyes it requires. So that is what all I'm saying. Okay, I have no legal view of this.
So from here on out, we're gonna focus on the work, the language, how we want this to look. We're going to address the chair. All right. I know I'm really bad at that, but we got to do that because we need to keep this focused on the work. My original idea was that let's highlight general areas of what's important. I really hope that Mr. Mordew will chime in. We'd love to hear from what you have to say. You have a lot of comments. It's good that you're here so we can hear from you in person. So if we can identify the large areas of either concern or how this should be structured, like, for example, like we talked about charter language, some of the comments, both yours, Commissioner Wong, and Mr. Mordew's, yours, I think. Identifying the process and procedure, being very clear on that. There's questions around when is the full commission approval required? When is it accountability? What is the role and authority of the executive director and or the DPD's designee? Those are, I feel like if we can identify those large areas, the buckets of work, that might help us focus the conversation. So I'll be happy to hear some thoughts on how that sounds to folks. Commissioner Benito.
Well, I think one thing is I'm not opposed to that, but, I thought that Mr. Mordew, thank you for reading it and giving us feedback. And I thought the written, it was really helpful to receive the written feedback, and I'm glad you're here. I thought maybe we could go through some of those points.
I think he's framing it already for us.
Okay.
You have some idea, if I may.
Yeah, my goal is to just not get bogged down in minor points, but if that, you do have your major points, so we can start with that.
Yeah,
It's fine, as long as we have a structure for the conversation.
Yeah, I thought that one of them that I think, and I see it on your list, is the going outside the disciplinary matrix.
Mhm.
So I thought that could be, especially, I think that's a pretty foundational question of what we're going to be looking at in terms of what kind of discipline what kind of cases we can impose additional discipline. I think that would be that could be a good starting conversation.
Okay. We have you here, so, I'm happy. Does everybody, you all got a copy of Mr. Murdew's points, right? Do you have that in front of you? Okay. I'm happy to start there. I just I want us to keep focused and not get bogged down.
Can we just let him present his
That's-
major
I
points
was
and then we'll
just-
go from there?
yeah.
I mean,
Right, let's start. Let's go.
Well, I guess you all got a copy of the email.
Yeah. Oh, you're gonna want to use the mic because it's being live streamed.
Okay, so, great. Sounds like everyone got a copy of the email in advance.
Mhm.
Okay, I hope that was helpful. That was my attempt to kind of take what I saw as the major concerns I had and synthesize them into one document for you. And I think if you were to break it into buckets, there's the question about when, if ever, is CPC going to get in the criminal referral business? I don't even know if that's related to the evidentiary process itself, and I think you all need to have a discussion about when, if ever, you're going to do that, because you're a disciplinary body at core, right? So you are the final disciplinary authority, and you think of yourself like an appellate court, for example, it would sort of be like the Court of Appeals deciding that somebody should be arrested when no one below them has issued an arrest warrant. It's sort of a strange thing to do, and it's a little strange to do when I think you want to look like an impartial body and not like you're out hunting for things that haven't come to you. Which kind of goes to the next point, which is when, if ever, are you going to affirmatively find cases, things that didn't come in through a petition, things that nobody has brought to you. Since you can only decrease discipline in an extraordinarily small number of cases, I find it hard to believe you would ever affirmatively take a case where you're just going to say, we affirm, we think this was great. And so the idea of looking for cases that you want to take yourselves in order to then increase discipline, it certainly doesn't look neutral because everyone's going to assume you only took it in order to increase discipline in the first place, which brings you back to the question of if it's so serious, why didn't someone bring it to you in the first place? And it's really, if you're going to go down that road, I think you need to have a discussion about when, if ever, you're going to do it in a way that looks neutral and a way that looks fair to everyone involved. The big question, I think, is when, if ever, will the commission leave the disciplinary matrix? The way it's set up, and forgive me if I'm misunderstanding how the discipline process works, but the way it's set up is that you're going to change the discipline if it's either incorrectly applied within the matrix or falls into one of these subcategories, which has been broadly described as contrary to the needs and concerns of the community. There's 4 sub-bullets there.
And I think my concern with each of them is that they're highly subjective. They're not even the same standard, right? So, yeah, I mean, if you look at the first one, it's, the community mistrust and discord, and later it's perpetuating fear and anger. I mean, the standards across these bullets are just all over the place. And, the adjectives are all over the place too. So the one that concerns me the most probably is the implicit bias one, because it's talking about explicit or implicit bias. I suppose you could all look at something and say, we've concluded that this was racist. It was done for improper reasons. It was a biased incident, fine. But if you're not going to conclude that it was explicitly biased, how exactly are you going to conclude that it was implicitly biased, which is also in there? And I mean, this isn't a setup where there's going to be a prosecutor and a defendant. It's going to be somebody presenting their side, somebody else presenting their side, and then you all sort of acting as partially a fact-finding tribunal from the top. So nobody's really charged with proving something up, though you guys have this portion there where everything should be by preponderance of the evidence. So I guess I'm highly curious how you all plan to find that somebody was acting in an implicit but not explicitly biased way. I think that's inviting challenge. And also I don't know if this is just a language issue, but one of them is the lack of cultural competence, and I think it's written in the way so that it's ignorance will subject you to higher discipline. I mean, I interpret ignorance as a lack of knowledge, and it's not willful ignorance, it's not intentionality, it's something where you just don't know, and that seems to me to be an odd category for increasing discipline, especially outside the matrix, right? You're doing something based on somebody not knowing something, not based on intentional misconduct. Then if you move to the next bucket, I'm just kind of going through some broad strokes. If you go to the next bucket, why you reach the decision you reach. And this is, I think, a really big question, especially if you're not allowed to go outside the matrix. This isn't hard, right? Then you just have a discussion about was the matrix properly applied. If you are allowed to leave the matrix and impose discipline that's higher than that, do you all have to have the same reason?
Yeah.
And, what happens if you don't? Does the discipline stand? Do you increase it and tell people, well, we're going to increase it, but we don't know why, because we can't agree, which doesn't really look fair. I think that's a really important issue that needs nailed down. And then on the briefing and hearing process, I think it looks like these were sort of written independently. So the briefing, it's like 2 pages, which is very, very, very short. They're optional, but then later it says you can only present evidence that was in your brief. So I'm not really sure what you can argue if you don't submit a brief, even though it says it won't hold the brief against you. And then the hearing process itself is limited in terms of questions and timing. And so people are very limited at the outset what they can tell you in writing, which is usually the clearest way to deal with these issues, right? And then you're limited in how many questions and how much time you can ask of the people when you're sitting in the hearing. And to
Can I
me,
answer your question on that?
Yeah.
Yeah, I think my understanding of why it was made optional is that sometimes with the disciplinary hearings, that sometimes the officers just choose not to attend. So often with the OPS cases, officers will just not attend. And so I think the idea was that if an officer or whoever is representing them, they're just not going to engage. We didn't want to make it mandatory, because then we don't want that to be considered an admission or something. So I think that's why. But I get I get the point you're making, but I just wanted to offer that.
So
And I guess really, not to take in too much, but related to that point is that we're giving the officers, if we look at the entire discipline system, they've had many opportunities, through the disciplinary hearing, to provide their version of events and so if we're providing a brief opportunity for the officers, which is probably provided on the petitioner side, things have to be balanced. The other issue is I don't think anywhere in there does it say that the petitioner can have a lawyer come with them, or it's just I think
it stops them.
Right, but I think it doesn't stop them, but it's written in a way that I am concerned about the balance of both the petitioner and the officer, And that's the only way you can maintain that type of consistency. And as he said, like my understanding always was, I've had discussions with Mr. Chura and Mr. Goodrick, is that our job is to simply find if there was a factual kind of conclusionary issue with the discipline, that were they actually guilty or was there new evidence? I guess we can introduce that. And then we go into the disciplinary matrix and see if it was properly applied. And the reason for that is not, in my opinion, to limit our ability to serve like the community, but the only way you can maintain consistency is with less discretion in a consistent process and a rubric, which is the matrix. So, anyways, go ahead. I'm sorry.
And then I'll just kind of round out my more minor points. The intake one, I just think it's kind of a curiosity because it talks about having a standardized form, but then sort of suggests people could make a petition orally at a meeting. I don't think you want to be in a situation where you're unsure if somebody has started a petition or not. And this seems like an easy thing to just standardize. I mean, you could use a Google form or something. The section on additional due process procedures, it's kind of concerning to me because I think a due process is sort of the minimum to which you're entitled by law. And when you start saying, well, we'll give you more due process if you ask for it, but we might not, it's just sort of a strange thing to do. I would think you want a standardized process that will be the same for everybody that goes through it. And then, if there are exceptional circumstances, maybe other procedures would be required, but that, your run-of-the-mill discipline hearing should look the same regardless of who's doing it, I think. And then the other ones are just kind of about bureaucratic overlap. And there's a reference to other evidence. And I guess this is sort of a question I have, which is, are you limited to the case file that comes up to you? Or is there a world in which you can consider facts and evidence that, say, OPS didn't have? I actually don't know the answer to that, but it talks about other relevant evidence, and I'm just curious, what is the other relevant evidence, and where does it come from?
I can answer that. I don't know if this is exactly the answer, but if,
Or why don't you let Martin answer it?
well, he does it,
You guys keep going. I'm liking this. Keep going, keep going, keep going.
it says actually in the charter that if we can order, because we don't have an investigatory body, we can order OPS to investigate. So I imagine if we found some flaw in the initial OPS investigation or the IA investigation, we can ask for more information. But at that point, I'm imagining all legal proceedings should stop. We shouldn't and we have to just push it back to the investigators. What would you do in that? And
I mean, this is kind of a deeper question here, right? Which is, are you going to limit the things you consider to what comes to you? And even if you order some further investigation, that's still a thing that came to you from the disciplinary process, as opposed to, we're going to go out and do our own fact finding. We're going to go on the internet and look things up. We're going to, do whatever, pick your option here. But are you ever going to go out and try and find your own facts or find your own information, or are you going to limit your consideration to what was on OPS or CPW or whoever had it beforehand? Are you just going to take this as a closed universe and not look at anything else? So those are kind of my broad comments, and I'm happy to answer any questions about why I made them.
Yeah, because otherwise I think we should just get into each of those buckets. But
Yeah. I think, I thought some of the biggest things that kind of stuck out to me, some of the things that I agreed with you on, I think I agreed with you on some things and disagreed with you on others. One of the ones I agreed with you on is the fact that the going outside the discipline matrix was too subjective and vague, and I thought that point was well taken. And I think that one thing that I was thinking about is, while we are developing this process, I think I understand the idea of wanting to have an option to, even if it meets the letter of like the disciplinary matrix, that there are still situations where you have somebody meeting the letter of the law, but they're still doing something wrong, right? And so I think that I think so. Okay, I'm sorry. So I think that the idea was, okay, sorry.
saying you're reading the letter of the law, but
So I was saying that I could see a situation where maybe there's a flaw in the matrix, then obviously you don't want to then say, well, we're going to go outside the matrix because we didn't like how the matrix was set up. But so I understood kind of that idea of if there's a situation that poses a grave issue to the relationship between the community and the police, wanting to address that. However, I think that while we're trying to build this system, it didn't really seem like, as you like reading your thoughts and thinking about it, I thought maybe this isn't the right time to try to do that. And that maybe what we could do is after, taking that piece out, and then after a year of having this procedure in place, revisiting it to say, do we feel like, of the things that we've created and laid out, what's working, what's not working, that could be a potential topic that we could revisit. But so I thought that was one thing that I thought about, is maybe we just take that out for now. That doesn't mean we couldn't revisit it and, potentially look at,
Just keep talking.
I had to say this, if I don't look
Okay,
in
we're
your
not gonna-
direction, that's
we're
not
not
a
gonna
sign
get-
of rudeness, my
I
gosh.
think, Commissioner, let's keep it, just focus on the subject, and so there's not back and forth on stuff that's not relevant to.
I apologize.
So what we're talking about right now is, one of your points, just a second.
I wasn't done yet either.
Okay.
Okay.
Then go ahead, finish, because we're talking about the matrix stuff, right?
Right. Yeah, so that was one thing that I thought I actually thought that was a really good point, and I think we should take it out. The other big thing that I was thinking about from your feedback was hunting for cases. So
So wait a minute.
Okay.
Let's stick with
One topic,
one
okay.
topic at a time. So otherwise, we're gonna keep jumping all
Sure.
around. So
Yeah,
we started on the matrix piece. Let's have that discussion, and then we'll finish that and move on. All right.
So I just wanted to, we talk about this matrix as if it's an abstract thing, but it is in the corrective action guidelines. I don't know if
I'm not speaking at it about it.
right, what I'm saying is that we should be looking at the matrix. It's already where the discipline work group is updating that. It's not possible for any amount of plan to plan for every single scenario.
Sure.
But I think instead of just saying, oh, there could be places that we can go outside the matrix, we should look at the matrix to see if there are flaws that we can fix now. And it was, I think, my understanding the matrix was fixed to narrow the discretion. And again, it's not, I hope that there is an understanding among everybody that is working on this. The matrix is just to, and please, Mr. Troy, more, is to apply and determine the level of, not the quantity, I guess, of the day suspension, right? So CPRB makes a determination based on the facts of the case, guilty, not guilty, whatever. They assign a group level, and there are descriptions in the matrix about the severity, because there are, like a wearable camera violation could, and then only could be group 1, group 2, whatever. And then after the group is determined, that is when the mitigating, aggravating circumstances of previous discipline rank could apply. So I'm agreeing with Mr. Mordu that I don't know if we have a kind of like a trump card that, we feel that somehow justice wasn't served. And that is a real consideration, because you just have this kind of gut feeling that with all of this, and that happens a lot in the actual judicial system. But to write it in such vague terms, and I just think it's very, and we need to think also about the long-term impact of this. If we do it for one case, because there's potentially community sentiment against it, another case could by its own value be just as concerning, but because there wasn't as much community interest, then we don't do in that case. And then my fear is that we are here not just to determine things for the worst cases. We are here to try to fix this discipline system, and I can only imagine that is possible if we have a fair and consistent system. Is it going to be able to, to serve justice, whatever it means in every case? Obviously not. But I think that is the general, so if it doesn't work, I guess because it's always an iterative process, if it doesn't work, then we reevaluate in a year, but I think we should be more conservative at this point. I mean, Mr. Morty, can you answer if we go outside the matrix in those cases would it,
Finish up the.
what do you think could happen in arbitration? I know you're not an arbitration expert.
Can
What
I
could
just make a
happen?
point? We're not, right now, our read on this is we don't go to arbitration, we go to court. So remember, we're not in the CBA, so I think that word is being thrown around incorrectly. We are not in the CBAs, right? And that is a good thing for us because they can't go to arbitration. That's what we identified. Can it be tested? Yeah. We might need to be negotiated into the next one. Who knows how that's going to all work out? But right now, we could not find any reason to believe that we are bound by the union contracts because we are not mentioned once in that. The public safety director is, the chief of police is. They are defined in how they work with arbitration in that cycle. For some reason, the CPC was not entered in there. So right now, our read on this, and Martin, you can correct me if I'm wrong, is the appeal for a decision that we make is to Common Pleas Court.
So maybe then you can comment on Common Pleas Court.
I have no comment whatsoever. I'm not your lawyer and I'm not advising the commission on any of these things.
And Terry, are you?
Well, Martin, would you like to comment?
Finish your comment?
Sure.
Yeah, at this point, it's almost like speculation. I mean, we haven't really, as Jason mentioned, and we've been discussing, we haven't really come to a solid conclusion on how this is all going to line up exactly with the CBA, the discipline process, court. It's not very clear to us until, unfortunately, we go in there and figure it out. And we can speculate all day, but we have not been able to that hasn't been built into what we see in 155 clearly, and that's been our guiding light.
I did request to have a moment to address this bucket, right? So 100% understand, and let me start by saying, there are very few community members who put in time, energy, and effort into our work groups and reading things that the commission does, and Mr. Mordew is one of them, so just recognition for that. Thank you. This was a heavy read and a heavy lift, and community members stepping up. He's not being compensated for his time tonight. This is just him doing this out of his heart, and that's great. That is what drives this CPC and always has, is community members like that stepping up and lending their expertise. So I remember clearly in my mind at the beginning saying constantly, our disciplinary decisions will have to be within the matrix that exists at the time, right? And I was maybe groomed to think that, right? And so here's where I would say, I hope I didn't curb your creativity. So originally the draft was very much based on that matrix, right? And saying, well, we have to look at the matrix, see if it comports, and that's how you make those fair decisions, right? But when Martin brought a new draft and had added to it, right? Because I had questions listed in the old draft that you would consider, right? Was this a biased decision? Was there discrimination in there? And Martin took it to a different level with his idea. And that is that the community, right, put you here, right? And we're in novel space, whether we like it or not. And sometimes being novel means not being afraid to try something and just see what happens, right? And the idea that maybe for the first time in the entire United States, a commission just makes a decision because they feel that's what the community wanted them to do, and let the chips fall where they may be on that, right? But I think that I was open to being bold there because you're going to probably have to go to court either way, whether you do it by the matrix or you do it the bold way, right? And what's the worst that's going to happen? You could say we tried it, we tried to do it on behalf, and is there ways to curb the subjectivity of that? Perhaps, right? But I do think that this discussion is worth having is, do you have a higher authority than the matrix? Can you say under 115.5, just because we want to, because we think the community wants us to, right? And so I know that's a bold question, but it's something to consider, is that you're in a new space, and a lot of people will tell you what you can't do and what you shouldn't do and how you should be afraid to try it. And I've been hearing that for 8 years here. And sometimes it's a limiter on our thought. And I might have been one of those people. I might have primed your brains to believe that the matrix is the only way you can make decisions. But once I found out you're not in the CBA, The reason the chief and the safety director have to live in that world is because the CBA binds them to it, right? So if they go outside of it, arbitrators will rule. Now, will the court? I don't know. And Brandon, I know you're not the attorney, but I didn't see in your feedback anywhere that says, 115.5 prohibits you from attempting this, right, in any way, shape, or form. And there certainly isn't in 115.5 a rule that says you're limited to the matrix. So these are things that we're discussing that don't exist in there. So at some point, people have to try bold things. So it's up to you, right? And by no means, there's no wrong answer here, right? There's the conservative way. There's the maybe more bold way. Maybe there's some middle ground where you try to have that trump card, but you find ways to make it more fair and across the board, right? But I'm not certain that there's any real limiter to that other than what you want to try as a group. And even I had to open my mind to it when Martin presented it and say, you know what, this is bolder than I would have been because I might have been groomed to that same conservative thinking. And I think the community is wanting to see some boldness sometimes from these groups, or else we get stuck in that same cycle of believing we can only do certain things. So.
To you, and Commissioner, I would love to hear from other commissioners' thoughts in response to this issue of matrix. If you have any, Commissioner Adams.
To the chair, I wanted to, all I want to say is I think that these 4 items that are being discussed are worth a serious dialogue. What we do know is that officers are getting trained in these areas. So the officers are getting trained on cultural competence. The officers are getting trained on racial bias, implicit and explicit. They get trained on use of force. So I think to completely dismiss it would maybe not be the correct thing to do. I do think that if we're training officers and things, then the expectation is that they're going to follow that training. So we should hold them to the training when we're considering discipline. So my suggestion would be to maybe think about sort of the standards or the ways that we want to think about how we approach the discipline based on these areas, because what's the point of training them on things if we're not going to hold them accountable for them if they're violated?
I want to just give other voices a chance, but I see you. Anybody else? Commissioner Churro, Tomlinson? Okay.
I'm a little bit troubled by kind of the rhetoric that we're using. Yes, to answer your point, the police officers are receiving training on these issues, but they're still, because we're in a quasi-legal, legal framework, there's still an issue of evidence, of intent, and that's a question we're not answering. And it's amply shown by the fact that the draft can seek to met out punishment that's beyond the matrix for implicit bias. My understanding of implicit bias is that everyone has it. And the implicit bias and the explicit expression is not always synonymous and is not matching. So you have to prove a causality there. And this is what I'm getting to be concerned about, is that we're using kind of words like let's be bold rather than conservative. What I mean conservative meaning basically let's be fair and consistent. That is what I think the legal system is aiming to do. I know it's a little bit imperfect. That is what the community wants too. And it is, I think it's predictably dangerous and perilous for us to be going into these other spheres that you can't measure and you can't prove. I mean, I'm not a lawyer, but I know that obviously something done with intent, without intent, has different kind of levels of punishment in the legal system. So that's my question. How would you even measure this? Because we have to measure it. We're going to be the 13 judges. We're going to have to assess whether there was enough evidence and be able to articulate it to the community, because certainly someone's going to end up unhappy in that situation, the officer or the petitioner. And that is why, and then the matrix already has, as much as it can, like labeled kind of these ways that you can measure kind of qualitative behavior. But this is the concern, is that we're talking so broadly about these. Let's be bold. I don't even know what that means. Let's hold someone accountable for training. What does that look like? How do you know that the training failed? How do you hold them accountable for these things. You can only hold people accountable for external actions. If you can prove intent, you can't read their minds, you have to prove intent. So these are all issues that really are, I mean, I really just like, can I just ask, why are we even doing this? Like, why are we running it before we can even walk here? We have not even proven ourselves to be able to follow a matrix, to follow a rubric for anything. And that is what would demonstrate our fairness and our ability to do this, to be proper judges in this situation. And now we want to add all these subjective measures, abstract, broad. So I would be fine with entertaining these possibilities if you can give me a rubric to measure explicit bias, implicit bias, to measure cultural competency. Until those things, we can't hold these officers accountable because they do have the training, but what is the measurement? The measurement is when they fail the GPO, right? And these are, of course, interpersonal type of things that are hard to ascertain, but we have to. And this is the thing; it's an imperfect system, imperfect in the way that we can't always punish people 100% because we can't know. But that is kind of the foundation of our judicial system, is that you have to have sufficient evidence to hold someone accountable for something. Otherwise, it is, and I feel I just say again, very personally uncomfortable that one of the measures for me is that I want to be an independent commissioner on an independent commission. Of course, we are taking in the needs of the community and their feedback, but we cannot be swayed by emotion. The only way that we can do our jobs independently is to look at the evidence and the facts, and also to use our common sense in other regards. But this is just extraordinarily troubling to me that we're going down this road, and now I hear that this is not Jason. All along, I agree. I will testify. He always said, just follow the matrix. Very simple. The matrix at the time. So maybe if I can have Martin, like, where did this even come from? These other ideas.
Director, you had a
I think we're confusing the idea that we're investigating, right? So here's a hypothetical. We get a disposition letter, right? In the investigation, sometimes they find things that are not charged, right? Or are misapplied. So you may be able to do this already in the matrix, right? So that started out as questions to consider in the matrix. That's how the original draft was listed. Some of these subjective things were just questions like, is there bias in the decision making? Was there something missed that's clear in the investigation? But you're not investigating the bias, right? But you may get an OPS report where the OPS person says, there was bias. There's no doubt about it, right? So let's take implicit out. Maybe that's the bad word in the draft. And semantics, we can change any of that, right? But let's just say the investigation found bias, but they weren't charged with bias. Everything looks like the matrix was used correctly, right? But it's there. But for some reason, you can't pin it in that matrix. And even if you did, there's a max, right? So now you're saying, well, this officer has shown bias. It was proven in the investigation, but for some reason, the way the matrix is being applied just doesn't work. So that means that officer, no matter what you do in that matrix, gets a maximum punishment, but probably they shouldn't be here, right? So those things do happen, because if you read enough of these disposition letters, you see that things that are what they are get twisted into something that they're not, even though the investigation found it. It comes down to semantics sometimes, and they call untruthfulness, intentional misremembering, and all of these things, right? So sometimes it is subjective. No matter how hard we try to eliminate it, there is going to be a degree of subjectivity. And yes, I agree 100%, and I've said this on the record too. The good thing about this is you also have the ability to change the matrix. So in a perfect system, you should put yourself out of business, and I hope in 5 years you're not doing hearings, because if you create a better disciplinary system, you shouldn't even be getting appeals anymore. So that should be a high priority goal too, is to put yourself out of the hearing business. But there are ways. There are ways where you can see it, where it was found to be true in an investigation already, but that matrix just limits what you can do if you're only using that, right? So if it's clear and convincing evidence that it exists, you may be able to, that matrix might have misclassified it and you're stuck there, So you might be able to say, you know what, in this instance, just like they use aggravating and mitigating circumstances, you could say this is such an aggravating application of something that the matrix only says 30 days, that absolutely we are taking it to a level of termination or suspension that it wouldn't have applied otherwise. But you're not reinvestigating that. And I don't think you have to prove it. You're looking for that in the investigation that's already done. So I don't want to get confused with we're investigating these things, because we're not. It has to be there somewhere already.
Mr. View, did you have anything to add?
Yeah, it wasn't like one of those Jimmy Neutron brain blast moments when I was working on this by any means. You know, when I was thinking about 115.5, they don't articulate a standard. You know, 115.5 is vague in a lot of areas, this area included. And when I wrote the words on the page, that we are limited to what's in the disciplinary matrix, I kind of just like sat there and looked at it, and I was like, is that what 115.5 says? Or am I just putting those words on the page because that's just the train I was going down? I always think about when you're going through a laundry list of items in any legal document, that sometimes at the bottom you're going to have a catch-all. You know, like a safe catch-all. It could be this, or any other duties assigned. You know, there's a good catch-all at the bottom. But a catch-all in this situation obviously needs some limitation, because the catch-alls could be very dangerous. It's a slippery slope. So I'm not a policy expert. I did some quick research on some items that could be good factors for a catch-all in this circumstance, and then I was relying on you all to have meritorious discussions about whether this is a good idea for us, if we are going to do this catch-all, and break down factors. What are the proper factors we should be considering? What are the proper words? Your comments about implicit bias being in there, I mean, that's resonating with me. I'm loving all of this. I'm loving all of this this feedback. So that's basically the origin story of it. And at the end of the day, if this commission feels like it's too much of a slippery slope, it's too dangerous, and we don't want it, then at least it's a decision that we all came to together. So thank you.
Commissioner Adams, you have your hand.
To the chair, I just wanted to add that when I hear the term bold, I think of doing something that has not been done. And oftentimes when you do something bold, it tends to be controversial. So I don't think that being bold, I mean, we are bold. The presence of this commission and the authorities that we have is something bold that the citizens of Cleveland did to get us here. And that was very controversial, and so that was bold. And so when you do things that are new and that people are not comfortable with them, then you will have some pushback. But being bold is not necessarily a bad thing, even in this sort of space. The second thing that I wanted to say is that we can hold the police accountable to their training. When they are trained in these areas, they are also agreeing that they're going to follow their training. If they're being trained on cultural competence and they agree to that training, and whatever that training is going to end up being, if they are trained in use of force is probably the most obvious, because I think it's just more concrete and clear, but we're training them. And so I do think that we can hold them to their training, and we should hold them accountable to their training. And my last point is that, to Martin's, that 115 is vague in this area, just like it was vague with the grants. So what we had to do was recognize that vague language gave us a space where we can sort of imagine and design and then execute a grants program. But what had to happen was that the next year we had to sort of reimagine and redesign the grants program based on the previous year's experience. So I think that we should be talking more about what we can do. We should not put the limits on ourselves. So I don't understand that if the sequence is policy, training, accountability, if they violate any other training, they could be held accountable. Why shouldn't they be held accountable for this training too? So whatever we train them on, that should be the standard that we use in these areas. I mean, I understand the subjectivity argument, but I also think that again, that because we're training them in these areas and there are agreements in place, that we should hold them accountable for those.
Okay, so we have Commissioner Wong, Commissioner Benito, and then we're gonna wrap up this part of the discussion.
Yeah, I was gonna.
Yeah, of course. You
So-
wanna go last?
So when I said how, when I said how does one hold someone accountable for training, I wasn't saying it's not possible. I'm asking for measurements, and obviously holding someone accountable for use of force because it's a concrete action, rather than cultural competency, which is much more abstract, may be easier to measure. But I do, and this is a rhetorical point, so I do want to make it that we cannot, I don't think it's right to take the petitions of citizens, which means it's actually taking their, the struggles they've had interacting with police officers as an experimental model. You made the point to the chair, the co-chair made the point that there were really not that many barriers on that grants making process. It was outside of the charter. And I have to say, it didn't go as according to plan. That is my concern, is that in the attempt to be bold and new, we cannot forget to see that we are actually responsible for people's lives and the outcomes of these discipline hearings, and whether these outcomes can be overturned is directly tangible. We will impact the health of the division. So again, it seems too vague to me to just say be bold. I actually think, now that we talked about it, if we want to make changes, make more specific kind of designations in the matrix, we should do that through the policy and accountability committees, rather than back end it with this catch-all that is very dangerous, you know. And I'm actually not a conservative person, but when I'm responsible as a commissioner for the lives of other people, being conservative is not a bad thing in that case. And being conservative with a legal system that we know is never going to probably hold someone responsible for implicit bias, is not something that is a bad thing. So I hope that we can actually get down to brass tacks and design these things instead of saying we're going to be bold or conservative. These are kind of just judgments. I don't know if they even have any meaning. I think it actually would be very bold, if I may say, to be fair and consistent. That's my idea of boldness. That's what I am not seeing from the anecdotal information and also from the Brady Diglio letters that we have read. I'm not seeing that. And that is, bold to me is actually fixing the entire system instead of using particular cases to pretend that we are actually doing something. Because there's a real issue here with the police in this city. This is the first city to have a second consent decree. So if we care about bias, the impact of racial bias, impact of use of force, we will fix the entire system. We will aim to do that. And that is my contribution to boldness in this commission. Thank you.
So, thank you. I think it's appropriate that you've spent the most time on this question, actually, because the more discretion the commission has on these issues, and I think this goes beyond the subjective objective issue, the more discretion the commission has on what kind of discipline it's going to impose, the more important all of the surrounding protections become. If it's a question simply of, are you within the matrix, was it applied correctly below, that's a predictable outcome. Everyone knows what the range of outcomes is there. But, you don't want this to become the Wild West where somebody says, well, what can happen when you go before CPC? And they say anything could happen. I wrote a parking ticket and they said I lacked appreciation of cultural nuances and they fired me. Which, it sounds like a joke, but that's possible as this is written, right? And so the more discretion you have, the higher the range of outcomes, the more you need to give serious thought to how do we make sure that we're doing this in a way that is remotely predictable. And it's not just that anything could happen when you come before you guys. So I just encourage you to think about that.
Okay, great. So that's a solid discussion. We can,
Jim?
Oh, Jim. Oh, Mr. Chair.
I think, for the officers and this whole process, if they do everything right, they're gonna get their due process, and that's what we have to do. And to me, bold is if the officer does everything right, you gotta be ready to make this tough decision and stand up for that officer when everybody else in the community is looking for their heads on a platter. So that's my idea of bold. I agree with, you must listen when I talk sometimes, because the implicit, you can't look in somebody's heart, only good Lord could do that. But, you know, explicit stuff, if it's there, it's there, and we'll handle that. Training, same thing, if, you know, some of this might be a little bit, kind of going in the quicksand there, but some of the training is pretty much clear, especially like with the use of force, exactly, vehicle pursuits, things that are gonna get officers in trouble, and, you know, people hurt or killed. And I just want to make sure that we give these officers a fair shake, just like we're giving the civilians a fair shake.
Okay, I kind of want us to.
Yeah, go ahead. Oh, no, it's not on this.
Okay. So, so you had we can go back through the buckets, right? So we dealt with the matrix piece. Where were you headed with that?
Yeah.
You can just go where you.
I think one thing there's still that we like, I don't know how we want to like resolve some of these conversations, but I mean, I'm on board with removing that. And, you know, I think we can always revisit it down the road.
Removing what? I'm sorry.
The section on the going outside of the discipline matrix, so that would be.
Well, I think we need to have that. I mean,
We can't make a
can't really
decision.
make
Don't-
decisions.
I'm not making decisions, I'm just,
Don't, yeah,
giving my opinion the same way you give
I know,
your
but
opinion, yeah. So,
we're actually taking action, so that's.
I suggested
Go
that,
ahead.
okay. So then the other area that I thought, we should talk about was the intake of complaints, and I think that part of that, there's, you know, kind of a streamlining and uniforming of the process, and then also, kind of the concerns that Mr. Murdu brought up as, hunting for cases. So one thing that,
So,
go
hold on
ahead.
one sec, because
Sure, yeah.
we're mixing things. I'd like to stick with the major points, and hunting for cases is one of those. I mean,
Yeah.
the intake piece seemed to be minor. I'd like to at least try to cover the major points in this discussion. So, you had said, I feel like so the affirmatively hunting for cases was your second major point. So there are questions around, you know, what that means. And so Director Goodrick, I'd like you to respond to that.
So there's two things. One, if we go down the order that Mr. Mordew, I like his buckets
Sure.
a lot.
Yeah.
I do. I really got to say they're good ways to frame this. So his first one was the criminal assessment, and I want to own that one because this has blown up into something that started as a concern of mine, and Martin and I have had some of our best debates around this issue that have led to frustrations and more frustrations because this can of worms turned into something much more than I ever anticipated. So let me give you where my brain was on that, right? We know, and one of the things we hear nationwide is stop holding officers administratively accountable only when they commit criminal offenses, right? So let me say it again. It's been said nationwide, and it's a known. Officers are held administratively accountable when a citizen is typically charged with crimes for doing some of the same things, right? We're seeing a lessening of that these days, which is a good thing, right? Now, there should be, I just want to be clear, there should be very few times where we get a case before us where they haven't already gone through criminal investigation, if it's even possible, especially with felonies. If a felony case, if something gets discovered where this is like, oh my goodness, this looks like a felony, and if it never got investigated, that would be so bizarre. I don't even know how we could get there, right? Where this came to be is there are charges in the Cleveland City Charter that are misdemeanor charges, and there are 3. And what you will see is typically the law department, prosecutors, the division, whatever, not pursue these 3 or use them very, very, very rarely, even when, and very discretionary, right? And those 3 are a simple assault, okay? So you'll see uses of forces where you and I would have been charged with simple assault, right? And for some reason, they aren't charged with assault, right? But those, if you did that, you would be charged, hands down. But instead, they're just treated as work violations, right? The next one is dereliction of duty. You will see sometimes officers charged with that and sometimes not charged with that. It's very discretionary. And these are all minor misdemeanors under Cleveland City Code, right? And then the third one is violation of civil rights, right? Again, it's there, it's very discretionary. So these are the three most frequent ones where sometimes they're never criminally investigated. It was never thought to be criminally investigated, especially dereliction of duty and violation of civil rights. If the case comes through OPS, for some reason they don't always communicate to IA to look at this, or they don't even look for it that way, right? So that's how it started in my mind, is that there have been a couple of cases where it's very clear the probable cause is there. It's common knowledge, right? So the idea that you need a well-trained eye to figure out if it might meet probable causes of falsehood. Any citizen can read it, look at the facts and say, yes, I think these are here. And under Ohio law, they're allowed to refer that to either a judge or a prosecutor to determine if a warrant should be issued. So that was it. That was the scope. Now, since that time, and so in subsequent conversations, it has turned into a lot more, right? So all the intent was there is that we should be aware of that fact, right? Because to Commissioner Wong's point, we don't want to become part of the system that is broken. So if the community continually sees us move forward with treating things administratively and ignoring the fact that this was probably a crime, we will eventually become part of that problem and not part of that solution. So we should have a way to know what might be a crime, to check and see if that crime was ever investigated. And if the answer is no, send it back for investigation. It's that simple. If the answer is yes, then we can move forward because it's already been investigated, and that's on them, right? It turned into a much more complicated issue than I ever intended it to be, and that's on me because I've just heard what the community has said, and and people are very concerned about officers not being charged when they should be charged. So we should have a trained eye on that. That was the intent here. It was not for us to get into the criminal charging business, not at all.
So I would respectfully ask not to have side conversations. I mean, I know they're minor, but let's just keep. Yeah, I understand.
It's a question from a community member.
So you can say that publicly.
Maybe I can state it publicly. So there were already issues about Garrity that Professor Rich and Professor Katz have mentioned. I just don't know if it's true. Is it true that if some evidence that can be used in a criminal case if it comes to us, we cannot use that to make our decisions?
So the Garrity issue is, you guys had Garrity training, right? So you could go back and watch. Fortunately, that was all recorded, right? So Garrity has to do with compelling a statement, right? And Martin, you and I have had this discussion. Maybe you could talk more about it, but compelling a statement because you have the right to compel a statement as the employer, right? However, if you compelled that statement and that officer self-incriminated in a crime, that one piece of evidence is no longer ripe for being presented in a criminal trial, right? It doesn't mean that crime still can't be pursued because there might be a whole other host of evidence. What it means is you tainted that particular issue that you compelled from. So I didn't even think we needed to get into the Garrity world. Originally, I didn't. But having subsequent conversations with Martin, and Martin had his due diligence, he did talk to the prosecutor. You're correct. He talked to Chris Vallant because these are the people who deal with Garrity all the time, right? So when you mentioned that he was talking to them, it was for the purposes of understanding this Garrity issue, right, and how it relates to us. So now the discussion of how does Garrity apply to us is valid, and do we need to be concerned about Garrity? It could be possible, but again, I'm hoping most criminal proceedings are done, especially the serious ones. And if not, the recommendation we've made, and maybe it's not clear enough, is we should pause that case and do nothing with it if there's even the smallest chance that it needs to be criminally investigated.
Do you have anything to add to that?
The Garrity issue has been, through the chair, the Garrity issue has been something that we heard the most feedback on from outside attorneys and people at large since the manual has been released. So since that time, I've had subsequent conversations with people that discussed more about their concerns around Garrity and the CPC, and I redrafted, or I sent over some additional language that we can decide whether we want to incorporate into the draft or not. That'll give us, number one, hopefully put the public and the prosecutor's office and everybody else that's watching this, give them a little bit more of a peace of mind. But it is to summarize the discussion, it's an incredibly complex problem that is difficult to articulate in a specific policy because it comes down to a case-by-case basis, essentially. When this commission we have our standard policies that'll help us try to avoid this as much as possible. But once we start recognizing criminal elements, we really have to pause and then take an individual approach of, okay, what documents do we have? Like, what kind of crime is being alleged? Where has it gone before us? And so there's a lot of like individual nuances for each situation that we'll probably need to address. And I kind of keeping that part a little vague in the new edits that I sent over, just so that way we can have a little, single touch basis for these cases, because it's incredibly difficult to do the white sweeping policy.
So if I can clarify this, I guess we were only talking about criminal proceedings. If something was said in the Garrity statement, can it be used in any proceedings administratively? Or
Gary's just, oh, can it be?
Criminal.
it
No,
can
just
be?
criminal.
Criminal only.
When you read your rights, you don't have to answer any questions. If you're going under for questioning under Garrity, you have to answer truthfully. If there's evidence that's showing this officer is lying, he could be fired for that. So you could be fired for making a Garrity statement, and maybe not even anything happens to you with criminally. But if you're going against Garrity, you could be removed. There's discipline. You have to make a statement.
Right, but I'm asking if that evidence, that part that was given in the Garrity statement, can it be used in our proceedings?
I don't see why not.
Yeah,
Okay.
it can be used in administrative.
So,
Administrative.
but not criminally. So then, it would make sense, first of all, for us to maybe we're gonna have to, I don't know if I can measure a criminal standard. For all of us, how are we going to set up a process that before we even touch the case, somebody can say, hey, you know what, there seems to be criminal kind of potential here. And was it properly referred? Should we refer it back to IA, refer it back to the prosecutors? Because the more we go into the case, the more we're going to face these issues. And what do we do with it after? And the more we potentially contaminate the case or whatever, or touch the case.
My feeling is if the incident occurs, it's going to have to be investigated criminally before we look at it. I could put that on the back burner like we were talking about. But
So who is going to do that? So that's something that we may need
that's
to
the whole
add.
thing. These should be investigated before they even get
Before
to
they
us.
get here.
But what-
Way at the beginning of whatever incident occurs, somebody should be looking at that as a criminal matter. If it rises to that level, that would be IA who would be doing the investigation. If they find out that it's not criminal, if there's a ruling on that, and it's not criminal, we go administrative. But even if they go with the criminal, we get them on that too.
But so if we do an intake, say, and then we discover independently, this is a new case that no one is then we have to refer it to the prosecutors. But what if it's already been referred through the system, but for whatever reason, it wasn't properly referred to IA and we catch it? What should we do at that point?
I would say we refer it to IA, but it should be caught if the system's working right.
Should be.
Yeah, and another, just one last comment on this. These comments, the new draft of the Garrity language goes into specifics about what we're doing in these exact circumstances. So I think we can put read that additional comments I sent over. Just let me know how you guys are feeling about that, because I think it'll be really helpful. And just a quick summary of it is, we're thinking about pausing as a default, pausing the case to be heard administratively by the CPC if we recognize criminal elements, and that criminal element is either going to be moved forward on or assessed, and we don't move until that actually is finalized. So that way we don't contaminate a prosecutor's file or a prosecutor's case. And in our instance, it's even more difficult to manage if we were to go the other way and just continue with our stuff, because we have open and public open meetings act. So the jury could possibly need to be screened out if they watched any of our meetings because that evidence came up. Like, it's really complicated. So I think, read over the draft language I sent over and let me know what you guys think, and we can have a further
So
discussion.
yeah, I apologize for that. I think you sent it only to me and to Jason, right? That was yesterday?
Mark, could you especially send it to the accountability committee? I mean,
Sure.
this is.
I can forward it
this
right
is-
now.
Well, but this is a continual issue. This is obviously an accountability procedure. We're happy to
So,
work with rules,
yeah.
but if
So this was
that's-
requested by me, so just so you know, that's why it came to me first. So it wasn't an intention to not send it to other people, it just didn't happen as quickly as I would like. So,
Well, the recusal process that I requested was sent to rules first and not to me, so.
To the chair, you did ask to move to the affirming cases for ourselves. So if you want me to spend a minute on that, I can. I think the criminal one, there's a draft, so we can take a look
Yeah.
at it and get some more feedback. And I just wanted to own that turned into something more complicated. But it's a good thing because if we didn't bring it up, it could have come back negatively on us for ignoring it too. So I'm glad these discussions are happening. And so, starting that simply, it just came back to being a very positive and productive conversation.
yeah.
But
So let's move on to the affirmative.
so,
And
but
one last thing, if anyone that's listening to this, if you have additional comments, because I'm sure my phone will ring tomorrow, please feel free to reach out. Please continue, because I want to make sure that we're staying on the straight and narrow on this specific topic as much as we can. So thank you.
And to be clear, we're not in the criminal investigation business. I think we're all clear on that. And so I want to make that clear. We are not looking to investigate criminal cases against officers in any way, shape, or form, but we are trying to be aware of the issue and the issues around that. So, why screen cases? So this was a great point, again, from Mr. Mordew, and I understand his concern. We didn't write 115.5. The commissioners didn't write it. And so the way that it's written that you can't go down is unfortunate in some ways, because I think that there are officers who probably deserve some downgraded discipline as well, because just as it works the wrong way, it works the opposite way wrongly too. So sometimes there are officers who they get more than they should have received. So, but unfortunately, we're stuck, and we can only look for one side, except under certain circumstances in 115.5, right? So that point we can't change. But what I think was missed in your comment was this: a citizen wouldn't know what's out there for a lot of the discipline. So the OPS cases, sure, you may get a complaint, and that was the originator of that. But a lot of the discipline that is inappropriately applied is internal, right? So it starts out as an internal investigation. A supervisor might have been forced to put charges on an officer. It goes through the system, and no one is watching that, right? So there could be a lot of misapplication of internal discipline outside that matrix that, unless we set ourselves up to watch that process and look for it, no one else would see it. So they wouldn't know to come petition us, because a public member wouldn't see those disciplinary charges unless they were watching. Some members of the public do. They follow that. Some members of the media do, but it also doesn't guarantee a petition. So I think it does two things. One, it trains us on that matrix, right? So if you're reviewing monthly all the discipline that comes through, and that is our standard, is the matrix, we should be able to get an eagle eye for catching cases that are outside the matrix over time, right? So looking at all cases and looking at them is not that hard, because there isn't that many. So that will help build your ability to recognize that matrix and know it really well. The other thing is too, because of 115.5, you probably should do that to keep the matrix, because you're also an oversight agency that audits, right? So on the same level, the question of, should you watch the whole system for its efficiency so that you can go on the back end then and maybe change the matrix? Absolutely. So you get two things with that, right? You learn the matrix really well. You see where the problems in the matrix are, then you can change the matrix, right? And also you can see if discipline is an extreme outlier and then start that hearing process on your own. So I think because of that internal, you would never get petitions, and it could stay broken and you wouldn't be aware unless you had that system for watching discipline that way. So that's the reasoning behind that.
I mean, that world of, perpetual audit makes a lot of sense if you were confining it to the matrix. But, as written, when you have unlimited discretionary authority to increase for basically any reason you deem within the needs of the community, and then you're going out and plucking cases on that standard, I think that's vastly different than saying, we're going to look affirmatively for matrix compliance, which might be its own thing, versus we're going to take the ability to have our full disciplinary authority all the way up to termination, under whatever standard we choose outside the matrix, and then you're plugging cases.
Point well taken.
Yeah.
Point well taken.
Are there any other comments on the affirmative review piece?
Yeah, I mean, I think point well taken. I think that we do have this authority over all discipline. And so I think that the idea of looking over all discipline, I don't think that would be something that would be problematic. The same way that we review all GPOs or we review all trainings. And so I think that that's how we're generally operating, is trying to review everything, to some very success based on our bandwidth. But I think Executive Director Goodrick put that well, and I think that, but I was thinking through, could there be an argument made about, well, you guys selected this case, where the discipline matrix wasn't followed, but then you didn't select this other case where this seems like an outlier of the discipline matrix. And, then could an argument be made that, well, why did you choose this over this person, right? And so I think that I kind of understand, and I think that in that type of situation, I think what could happen is then some people would say, well, we'll look into that case, right? And so I do think it's important that we are looking at all the disciplines, because also the idea of if we were to only take cases based on people making complaints, coming to us and saying, I have a concern about this, not everybody in the community knows that they can do that. Not everyone in the community might feel safe being the one to come in and say, I want this case to be investigated. And so there's a lot of different reasons why someone might not be the one to come in and make a complaint themselves. And I don't think that means we shouldn't, potentially being reviewing that discipline.
Yeah, so if I can synthesize a lot of the points that I'm hearing is that while these are things that are nice to have later on, I don't know if they're must have right now, especially when we are overwhelmed on grants, we're a little bit overwhelmed on policy. There seems to be a differential, difference in understanding about the discipline system because of the proximity to certain documents and life experience. So why are we, I guess that's the core question, why are we hunting for cases, is to use your language, when we haven't even done one case, which is incredibly dependent on this records process, because one due process requirement is a timely, adjudication of a complaint. And what I find interesting, if I may point out, is that is explicitly mentioned in the charter, is our records request power. We've never enacted it with a majority motion, which has caused us not to be able to move forward on our single pending petition, which has, a lot of it, which is a significant case. So again, what the pattern I see in the commission where we falter is that we bite off a lot and we want everything, but we haven't built the capacity for it. We haven't built, the capacity means we have to build a process for it. We had to build the knowledge, the subject matter expertise to do that, to fulfill that process. So this is my argument here, is that there's plenty to do. And again, I also want to say, you're putting a really heavy workload on the accountability committee. You're making decisions for something that may never impact you as a commissioner, because the accountability committee will be looking through all these cases, making the dossiers, doing the brunt of the work, right? So I'm not finished, but so why can't we do something that all of the citizens asked for, is that to just fairly look at the cases. I mean, that would be a great accomplishment. I imagine actually, if we are able to fairly adjudicate these cases and find the flaws systemically within the matrix, that would cure a lot of the problems within the division. My concern is, and also what I've seen is that we do have a tendency to lose focus off of this systematic failure, right? That was what the consent decree says, systematic failure of the division. And then we go here, we go there, and we're nibbling off the edges. And here's another fire that we had to put out that may not actually be the core infernal that we're dealing with. So I just don't understand, like, we can always change this process. We can expand it. I would actually advocate, maybe if we write this process, that we do it on a time scale. This first year we do this. This is like our goal for this year. And then after 5 years, we can do this. Obviously, and we don't have to hunt for cases. If a case is of such extraordinary importance, we will know about it. And we have the right to take that case. But I'm just concerned again that we seem to be in the same pattern of behavior, is that we're designing a process without even understanding our capacity and our knowledge and the workload that is put on the accountability committee. I still, other than me and Mr. Chura, I don't think anybody has read all of those disciplinary, and Ryan has read those documents. I mean, Martin even did not have some of the documents or the manuals for CPRB before he wrote this process. So we have a problem. I would love to take on all this work, but all 13 people
Okay.
need to pull this plow here.
Your point is made, Martin, and then.
Through the chair, just a thought, I didn't see anything. This is another one of those areas in 115.5 where it's not clear on how this process works. So put this in here to generate a discussion like this. So loving it. Thank you. I would be interested to hear what the community's expectations are of the CPC in regard to this specific item. Does the community anticipate that we're only going to be taking cases in a passive nature where they come to us, or are they having an expectation of us to go out, or of you all, sorry, not me, to go out and to be more of a auditing surveyor sort of approach, hunting style? I don't know. I think that'd be really interesting. Number two, I understand maybe taking approach of draft it more conservative for now, and then that way we can balance the workload more efficiently. I think that's a point that shouldn't be missed. And then what's to stop a commissioner from being like, you know what, I'm going to be the one that's going to submit the complaint on this. I mean, or somebody could come in and just submit a complaint. So you see one that nobody has raised an issue or brought directly to the CPC. All right, can you go over there and fill out a form? Yeah, sure, I'll fill it out. Like, maybe that takes the duty off of us, or you. I'm sorry.
Director.
Having read so the way that this process that I would propose doesn't have to be time consuming. Okay, you don't get that many disciplinary letters in a month. So even if you got 10 in a month, right, you would have access to those. You read them before you come to your meeting, right? And then you just, if everyone will, it's just like approving the minutes, right? Say, did everyone read their 10 cases? Yes. Did anyone have any concerns? It could take as much as 1 minute. If everyone says no, nobody saw anything in there, right? We can even develop a quick check form that everyone uses if you wanted to. But it shouldn't take a lot of time. And there is no better way. So Ms. Wong has made the point infinite number of times that the best way to learn the system is to read everything. There is no better way to do so than to start reading every single disposition letter that comes your way if you're on accountability every month. You will learn exactly how they think and why they make their decision and what aggravating and mitigating factors. And when you have to do hearings, you will have such a better understanding because you're reading the world that you will be forced to live in and you have joined up to live in. And the community has said time and again, discipline is their most important thing. I have heard no greater concern from them other than discipline. They want to see that you guys get involved in discipline. It's been said at this microphone so many times. It's not that big of an ask for you to read and become familiar with the way discipline is being done. The monitor team does it. They check these things. They read them so that they can understand how it works. Further, you'll be able to learn different safety directors, how they do it, how the chiefs do it compared to other chiefs. It is so, you can even tell who did the discipline by the letter over time because of the way they think and move. So it's 100% a great way to learn. There's no better way to learn. If you want to be experts in discipline, start reading those and reviewing them.
Commissioner Wong, and I'm gonna go, and if somebody else hasn't spoken.
So, I do appreciate, the encouragement to read as much as we can about these, letters, but, and I don't know if Mr. Mordew has a comment, and Mr. Chura. If you read these letters, though, it's not necessarily going to give you all the information you need about the rationale for the discipline. Sometimes we are often very confused, and we do see, inconsistencies that we just see and then we sense. So I'm not sure if that is the best way to identify things. And when I was in discussion, with Mr. Mordew about, the core question was, how can one go out, how right now in the system, how is the division even going outside of the matrix? So that's a very salient question because I think because there was not, that much, and I couldn't exactly answer the question as Mr. Chura did, but one way that we're missing is that they won't even charge the officer at all. So if that is, those things can only be found probably through the full disciplinary file, because there would be some type of Form 1, some type of complaint from a lawyer that we would never see. So I guess we're just, again, biting off more than we have because we don't, that is the records that we are being intentionally or not denied at this point. So I'm concerned that by looking at, yes, you can look at the divisional notices and send some stuff that are arrived, but I don't think it would be reading between the lines, and it would be kind of like a gut reaction that is not very reliable. So one of the capacity limitations for this process are the records, are having a relationship that is with the division, that there's constant sharing of these records, there's no resistance. So I think we're planning, so I would, again, propose an on-ramp, multi-year on-ramp for this. We can develop plans for year 1, year 2, year 3. So, but I just wanted to know that is, I don't think that is a very good system just by reading the disciplinary notices. You would have to do a statistical, I think, analysis. What we've done in Brady Gig is we've looked at multiple hundreds of them. I am very concerned if we just read a letter and have a sense and then pick that case.
All right.
That would not be the way I would go.
It hurt.
That's not what the process says.
Yeah, reading the disciplinary notices, I think it gives us a good little synopsis on what happened. It's, doesn't always get very detailed, but sometimes they do. And officers, usually they'll read all the DNs at roll call, so it's a good learning tool for them to see what guys are getting in trouble for.
Yeah.
And to avoid getting into that trouble. There might be certain cases, I think it's been years since they swept stuff under the rug. It's a couple of chiefs ago, but I think for the most part, I think if they get a hold of something, everything's on the up and up. It should be on the up and up. Sometimes discipline might not be as severe as one might think, but we'll have to look at that. But I think the disciplinary letters are probably pretty good. Give you a good idea of what's going on. If you need to delve into something alarm goes off in the back of your head and you think something's fishy with it, then we could always look at it deeper. So.
And for clarification, the process right now doesn't say that we take a case just because we read the discipline. Then we just initiate the process to get more information, right? So then you would make your determination if you're going to do a case. But all you're doing is flagging, do we want to have, to Ms. Wong's point, more information about this, right? So you will feel it. I'm telling you, you'll get, Ryan and I can the hairs go up on the back of your neck when you read one and say that doesn't make any sense based on what we know about discipline or what we've read. And those are the cases where you will say, now let's get more information. You're not committing yourself to a hearing. The process is just review on a regular basis, monthly basis, through accountability, the letters. And if you flag one that might require more investigation, you then make the request for the records for it. It's not really, there's no negative side to it. Yes, it requires a little more work, but you were tasked with doing work already. That's what your work is.
Okay, so quickly, and then we're gonna move on.
I take back what I said thinking about it. Talking about that there's no difference than filling out a commissioner than being like, oh, I'm going to fill out a complaint form. As we have it built in the rules right now, anyone that fills out a complaint form, a CPC complaint form, we automatically request that file, and in order to dismiss that case, it has to go to a full commission hearing. How we've structured it so far in the manual is any case that we bring on our own, the accountability committee has the ability to dismiss that case on its own before it requests that file. So there is a little bit of a nuance there, and that structure we're not married to. So feel free to continue to discuss that structure and how we've implemented it so far.
Okay. So I feel like we've talked about this enough, and we've got a lot of work to do in figuring it out, but that's not going to happen tonight, right? So I'm looking through what's next. Looking at the matrix we've already discussed. Briefing and hearing process, have we talked about that? The question from Mr. Mordew was, I don't understand why only one side gets briefed, why brief should limit to 2 pages, and that I don't process it. Optional brief, limited in length. So if you'd like to talk about that a minute, Mr. Mordew, and just start that conversation.
Yeah, I guess this could just be a little bit of a difference of worlds. Most of my world's on paper. And you go to oral argument afterwards, but you've already submitted your position essentially in advance. You've had a chance to think about it. You're not on the spot. And so I think getting clean, reasonable length submissions at the front end should help focus all of the issues at the hearing, right? Again, it's an unusual situation because you have a complainant who's a public member, and then you have an officer. There is no prosecutor here. There's no one trying to prove up anything. And so in some respects, people are going in a little blind. They just know what discipline was imposed upon them before they got to you, and then they know you're taking the case. And, again, this does link back to, are you going to leave the matrix or not? Because if you're not, then they know, okay, well, now here's their evidentiary manual. Here's what's going to happen. Here's what I need to argue in order to keep the discipline or argue that it was correctly imposed. But if you go outside of that, then they have to start addressing, do I have to say whether I don't think this was racially motivated, or that, any of those other sub-factors that were listed there, and giving people basically a couple tweets to make their point is, I think it's kind of insufficient. So it's just my general view on that.
What do you think would be a reasonable length? 1,000.
I mean, the joke is always that lawyers are the only people that can write a 40-page document and call it a brief. But I 5, 10, you can do things in a short period of time, but if I remember correctly, the manual had all sorts of things that they wanted you to include in your brief that would take up a lot of that space. Maybe I'm misremembering that, but I thought it did. Yeah, case summary. That's case. But I mean, I think 5 pages is more reasonable. 10 pages, they should certainly be able to make their points in 10 pages. So.
I just thought about this point. It's much more, we're allowing the union's attorney to help the police officer. There's a kind of a disbalance here that I certainly didn't have any lawyer helping me when I made my OPS complaint. It was just, I guess he had the advocate of the investigator. So would that be fair because you have one side that can present with a professional's help 10 pages, and the other side, I mean, what are we requiring from that? The other issue I wanted to ask, I don't know if we're doing it later, because I understand now you're more fully your point about going outside of the matrix. So if you look at these these letters, right? There's charges, and sometimes they're phrased slightly differently, whatever, but they're basically the same charge, like wearable camera violation. But there could be more abstract things because the word truthfulness and honesty, they're all different in the manual rules. So one question I have is that, are we going to just follow the charges that were made by the charging officer? If we find that can be someplace for example, where bias comes up, and that is what you actually mean by, that is actually what so I guess we have a way to solve this. If, say, something that was not charged, we believe there's evidence for it, we should still go back to the matrix and say, how do we measure this? Are they guilty of this? And how do we determine the group range? So is there anything, so we can add another, so that's one way to solve it without, I think the way it's written though, it's just like, oh, how we feel about like this abstract thing, and then we can add to, it'd be like an aggravating circumstance. If we can still contain it within a rubric, that would be possibly better. I don't know if that's something that we want to do. And my last question is to Mr. Mordew. I've only attended one appellate hearing. I imagine that the evidence that was presented was always from the lower court. They were limited to that. But the three judges asked very different questions. They probably have different reasons for finding guilt. That's a little bit different than what you're saying in that one point, is that say Commissioner A is because of this charge and Commissioner B is because of that charge. But I think that's probably already resolved because the charge, right, there's like, say there's 5 charges. Every charge has to be assessed according to the group and according to the matrix. And then I guess we do a cumulative effect, and then we met out what the punishment will be, which we're not even doing, right? If we find, like, does it still have to, our finding, does it have to still go back to the safety director?
So no, well, we then order them to we don't work. I think what it says in 115.5 is we are sending an order to either the safety director or the chief to impose discipline, right? So we're actually telling them to impose a discipline. But this one is a strange issue because, again, it got more complicated than it really needs to be. If you look at every step in the process before us, no one's doing briefs, no one's doing any of that stuff. At OPS, right, an investigator gives their findings to a board, similar to us, right? The officers probably invited, they have the chance under their rules to speak. Most times they don't, right? And so really at the simplest level, all it takes is somebody saying, this is what the matrix should be, and another person saying, we disagree with that, we think it should be this, and you making the decision, right? The original version that I wrote for this, I used other state boards, employment boards. They are very complex. Some of them go as far as motions and answers and all of that stuff, right? And then when I showed that to somebody on the DOJ, they were like, why? None of that is actually necessary in this particular situation, right? And so it made me rethink, do we need to make this extremely complicated? So what that got whittled down to was, should we even do oral arguments, or should it all be in writing and you just make a decision, right? And then the other thing is, because time and everything, right? Then, we understand there's Laudermill and all those that require the rights in when you're doing administrative, and you might fire somebody, right? But there's really simple answers here, so you could make this as complex as you want, and you could probably make it simpler than it is right now if you wanted to, right? So the question of why short briefs, because why not, right? So we don't have to make it as complex as a court. And if you're only looking at the matrix, there shouldn't be long, lengthy arguments about why it's different under the matrix. We're not revisiting the case. We're not reinvestigating the case. But at the same time, you don't want to make it so long that they can put a bunch of rhetoric in there and all kinds of stuff, right? You should be able to argue in 2 pages why you think the matrix was misapplied, and then a counter to that saying, no, the matrix was correctly applied, right? So since we're moving in that direction, that's the real question here is, how simple can you make that? Because if you're only arguing about, did we follow what the piece of paper says, we don't need to overcomplicate this, really.
Okay. So I think unless there's an urgent thing that needs to be said about this, do you have any response?
No, I would just say, yeah, I agree with that. I mean, this does tie back to the core question is, do you leave the matrix or not?
Yeah.
Okay. So I feel like we've had a pretty good discussion on all the major points, and we have 15 minutes left. I would like us to figure out how we're going to just what our next steps are. I mean, the minor points, we can figure that out, I think. But it's about, yeah. So unless there's something somebody really wants to talk about in those other points, but we need to make it quick because we need to.
I would suggest we take it to a work group and put a hard deadline on it.
Yeah, I mean, I would say either a work group or just a few people getting, yeah, it's a work group. But it's like less formal, the better, so we can get people working together and writing together. I think would make sense. So
But I would also say put a deadline on it, or else it
Yeah.
could go forever. So
You rolled your eyes. So
No, I'm just, well, the deadline was caused by not having the collaboration at the beginning. Again, I
Well,
wanted-
so let's not go
So-
to that place right now. We've got a
But we need
proposal, we've
to-
got an idea,
that's fine.
so let's
I'm
just figure out how we
happy
move
to
forward
leave,
rather
leave
than
that
talk
work
about
group
what
if
happened
need
in the
be.
past. So,
and I think it should, I would advocate, 25 pages is very, very long. How much?
right,
there-
so I don't think we're
yeah.
gonna get into what's too long right now. We're gonna have a work group or a group of people who are gonna work informally and write and take everything we've talked about tonight. If they need other information, they reach out to other people. So we don't have to worry about what the right length is. That group will figure it out.
But I would request that anybody in this work group would read the basic disciplinary documents. I can't imagine that it would be very helpful for people that, just maybe because they didn't understand the
Okay,
system.
great.
Thank you.
So, go ahead, you got something?
It would be good to hear, I mean, I really like how we've broken down the major points of discussion. I think, we're starting to hone in on the real areas where we're looking for feedback on them. And a work group, I feel like I'm afraid that we're not gonna get as much feedback from the commissioners on each one of those items, to see how everyone's feeling. Work group, we kind of go small and then grow out versus like, how does that work group know what direction is really the direction the full commission wants to go on each one of these items? Like, is there a way that we can think about getting feedback from the commission on like some of these key points and then we can hit the road? Or, I don't know, it's just a thought.
Probably, we can maybe synthesize the core questions down to, and maybe, I've already sent out Mr. Mordu's comments. I think though, I'm a little uncomfortable because we have very distinct opinions about this. But I don't think it's like, oh, let's just try this. I think there are probably some legal kind of barriers that we need to put on this. So if you want to seek like comment, I guess we can seek the comment and then we can take it back to the work group. I personally do not want to be involved in a draft that I know is going to be unfair and inconsistent. Or we can just, I think we have a fairly critical consensus here. Can we say a little bit about how we feel about the questions that Mr. Mordu? So we have 7 commissioners here, or
I feel like
6,
we've
right?
already had that discussion. I don't know if we need to go deeper into it. I feel like
So we
everybody
have,
who's
yeah.
had an opportunity, we have, I've got notes, I don't know.
But we don't have a consensus, I express
We don't
consensus,
necessarily, I
right?
think we have a general sense. I think that's all we need, and we can take what we've discussed here and turn it into a document. It doesn't have to be if you don't want to be involved, that's fine. We can make
It's
it
not that I
work.
don't want to be involved, it's
understand.
just that there is just resistance against like logical points that are very, very
I
clear.
don't see a lot of resistance to that. I see a good
Let me,
discussion,
I
but-
wasn't finished, I was, this came to pass after I opposed this
So
draft,
let's not
you
go
know?
back to, we've
It's
said
not-
this a number of
but
times.
this is a process
I'd like to-
issue,
It is not a
Pete.
process,
It's a process
let's move
issue.
forward. Let's move forward.
So are we going
Figure
to,
out-
I would
Would you
not,
like to be involved with this process?
I
going
would,
forward?
if, I do not want to edit this draft though, I think there's
That
enough
is not what we're
problems.
talking about. Would you like to be
So-
involved with writing a document? It doesn't have to be a draft, like redraft.
I
of
think
this
this
and
draft has
redraft.
enough problems.
We've heard that repeatedly. I'm just saying, it doesn't have to be that.
Mhm.
Your concern there is unfounded. We're gonna work on
That was squeezed.
writing something, and we're gonna do it in a smaller setting. We can get some feedback. So do you want to be involved? Who would like to be involved with this process? That's the question at hand.
I have a question. So, I guess what I hear Commissioner Wong saying is that I don't want to be involved if it's not a rewrite of it. I think that we can address these points by editing this document. So I guess in terms of saying who wants to be involved, because I don't totally know if, like, I feel like we might need to set some parameters on, you can always write something. That has been open to you from the very beginning.
That's not true, but,
No, I think at least I'll say that I feel like, from.
Well, how about this?
No, I'm still speaking, thank you. That since we first reviewed it in the Rules Committee, you said that you were going to rewrite it. You said you needed more time. I'm still totally open to read something that you've written. And so even if the work group is not just sitting and rewriting something, that is still an option for you to write something new. But I do think that for the work group, we should be taking this draft, and there might be sections that we write a new version of. But I don't feel comfortable saying, like, joining a work group that is saying that we are not going to use the draft that we currently have. Because I don't see a conflict between addressing the concerns that were brought up today and Mr. Mordu's concerns and points with revising this current draft.
So my concern is, we went through the broad issues. There are sentence by sentence problems, paragraph by paragraph problems, and those are amounting to 100 comments. So whatever it is, changing those things would essentially be a rewrite anyways. But I think the draft, I mean, because like all first drafts is long, right? You want to distill down to a simplified process that was the concern from multiple lawyers, that it was dense and it was long. It's hard. We had to also think about whether it's readable to everybody that needs to be. So it's essentially the same thing. And the reason why I want to express is not like I'm not willing to work on this, but it does seem like I'm not going to spend so much time on something that because you're wedded to a draft that I think because of how it was not fully collaborative at the first, it's already tainted by that. So why not just start over? Sometimes some things are, if you has 100 comments, just start over again. It's not like we're not going to take elements of it. You know, we've learned a lot through this. So, but if we're just going to sit there and edit, you don't get to the deeper issues. And Mr. Morty's not going to be here explaining all those things. If we're just line editing, if the draft is, and this is my problem with a lot of the drafts that were in rules, they're not ready for editing. Editing is the final step. You have to really.
I'm going to suggest that I don't think there's that much difference here, right? So it's like we have a draft, we can pull from it, we can start with fresh eyes and all the comments we've had, discussions tonight. I don't think we're going to get hung up in like, is it a new version or is it a draft? Or just rewriting a real draft? I think we just need to come get some people together, working with Martin, Jason, whoever can be involved, and a couple of commissioners, and just really start. So whether that might mean if you want to write a draft, and we can say, like, how much time does that take you? When will you have a draft to us? And then we sit down together and go through our understanding, and we edit your draft. I'm fine with that. And we'll pull things from the previous version, maybe, whatever. Right. But we don't need to get stuck in how this is going to move forward. We just need to move it forward.
That's fine. So I will write a draft as best as I can. I will incorporate, but I don't feel comfortable. It's nothing against Martin. I really do believe that he is in a wider conflict of interest. So I will work.
Martin will be involved with this draft, I think.
He'll be, yeah. Okay, so he will, but I want to limit my interactions in this way. It's not because I don't believe you, Martin. It's also to protect you. We've asked you many times to announce whether you are in this conflict. So I'm happy to work on it. There's not that much legal things that are actually in this draft. So I will work on a draft. And then we can have a work group come together. We should probably have a deadline of probably a few months, though, I would guess. 2 months.
Okay. How long will it take you to write a draft?
I don't know. I'll have 2 weeks.
2 weeks.
Okay, so but I want to get the consensus here is that we still don't have a consensus about that core issue. What cases are we out? So if people are able to marinate about that, think about, are we able to go out of the matrix? Do we want that? I would again, please look at that GPO because you'll find that a lot of the things that we're worried about that we would maybe like to go outside the matrix are actually addressed by that GPO. And that is in the I can send it to everybody. So
I think, I don't know that there's an exact consensus, but what I've heard is that if we do go outside the matrix, and then we have to be pretty clear on how that works and what that means. Like not just, get rid of as much subjective language as possible. Think about the training piece, what they're trained on, and what's fair, and to officers as well as the community. So I think, is there an exact consensus? No, because that's not our goal tonight. But we've heard a lot, and I feel like what we have is the ability to move forward with something that keeps us inside the matrix and looks at, are there reasons to go outside the matrix? And maybe in a draft that's written, you don't address that, but we'll take it once you have the skeleton of what we want to do. Then we'll kind of work on it, and we can come back to this group or come back to accountability or rules. And
does someone at this table not want to be part of this work group? Like, what's the difference between this work group and us?
Can't have this many people on the work group. Yeah.
because it's 7, so we can't.
Well, and even
But for the pursuit policy, we had a bunch of commissioners that were interested also.
I think what we need is a
With
core
six.
group who can kind of work together
And
and
also
just
writing's
come
not
back.
done like
So I'm
well.
not, so is there a group though? I'm hearing one person writing, so if it's collaborative, who else is on the shared doc? and everyone
I'd be
feeding?
happy to work with it, and I'm happy to respond to a draft from
Yeah, but I'm just,
Commissioner Wong.
all I'm saying is it's probably best to have a small set of people just write the
Right.
initial draft and then you work on, you don't want like 6 people starting from scratch.
So I mean,
And to be
Yeah.
clear, again, there's no emotional attachment to that draft. It was a great conversation starter, obviously, but if only 2% of the words that were in that made it in, no one's gonna leave the room crying. This is what work is. So
we have a plan for a draft for Commissioner Wong in the next. See, today is May 1st. That's May was it 15th? I'm fine with that. Does anybody else want to be involved? We will certainly call on certain people. Looking at Mr. Commissioner Chura, who has some
Subject
expertise.
matter expertise. Okay,
Um,
June.
But if anybody else has thoughts,
No writing, just subject.
yeah, and we'll try to be as specific as possible and not like involve you in a 3-hour conversation in the evening. And then, we'll have the staff involved and we'll go from there. And if we have specific questions from Mr. Mordew, without involving you in a long conversation, we can ask you too. Great, okay. Maybe not.
You could try.
You can try. We do really appreciate your willingness to
thank you
show
for
up and
coming
to
in.
explain, go through all that. So we have a plan, and that's it. And we are at,
do you want the public comment?
we have 3
Please.
minutes. Public comment.
All right, now, is this on?
Yes, it's on.
All right, now, this is time to make the comments. I will make that as short as I am. First of all, writing a documents for a work on police reform is different from writing a grant applications. You actually need to avoid too many adjectives, like bold. If you do the job correctly, you will do this part without saying it on the paper or on the computer screen. The words you need to focus on will be verbs and nouns. Think about qualified immunity. You need to tackle that. Don't think about being bold, being creative, being all those. Those would not really help you. Yes, reading it emotionally, you are very fulfilled by that. But people in the community needs that to be transformed into an action. So please, when you're writing all these documents, avoid adjectives, put on more verbs and the nouns. Otherwise, how would you define all those adjectives in your whole document? That's the waste time and energy. So today we do not see lots of bickering, fightings on the camera, but that doesn't mean the tension did not happen. So please understand it. The community really put a lot on you, which you may not be capable of doing. But if you are willing to learn, please listen to the experts, especially on the subjects. Do not think these experts, just because they are brought up by a particular commissioners you are not too fond with, you don't think you can work with, so you will reject those people. That's the reason why last time, the Wednesday, the public meeting, I did not make public comments. One person made the comments on my behalf. Please do not let people think that you are always getting on a particular commissioner during meeting, before meeting, after meeting. This is not a good sign for the community to see that you are growing, you are learning, you are working on issues. Don't go backwards, please. Thank you.
Thank you, but we're out of time. It's 8 o'clock, so we will adjourn this meeting. Unless.
Was there someone else?
Okay,
Luca?
all right, real quick. Sorry, I didn't see you.
Will this new draft be brought to the public before it's passed? Will we have a chance to hear the revisions?
Well, we'll probably have to come back to this
It has to
group
go
or
to
the rules
committee.
committee or whatever. We'll figure, there will be something before the full commission
Okay,
sees.
I'll be here then.
Okay. All right, great. All right, we are adjourned. Thank you all.
Yay, I love a good meeting.
Oh.
Makes my heart feel full. I love it.
Thank you, Mr. Martin.
Yeah, thank you.